Making a false or misleading statement to a public servant in Seattle or Washington state. What is it? And what do you do about it if you're charged with that? Well, my name is Lance Fryrear, and I'm the defender of justice. Defender of justice. Defender of justice. Defender of justice. And I don't normally look like this. I look like this. And that's because I'm a defense attorney. And I have a law firm in Lynnwood, Washington that's been defending people charged with crimes for more than 20 years. And in this video, I'm going to cover what is making a false statement to a public servant, including the penalties. What are some common situations that can get us into that trouble, situations to avoid, and most importantly, so watch until the end, is how we can defend those type of charges. If you're in that situation, what we can do about it. And again, I put out these videos to help people, to educate people, try to figure out what to do, to learn about the law. So if you find it helpful, please stay to the end and either like this video or subscribe to our channel. It'll be really helpful getting our message out there because I want to be able to keep helping the public, keep helping you. So making a false or misleading statement to a public servant. How is it defined and what is the penalty? That's number one. So basically the statute reads, a person is guilty of a gross misdemeanor crime if they make a false or misleading material statement to a public servant in the discharge of his or her duties. The material statement means something that law enforcement person would be reasonably likely to rely upon in executing their duties. And again, I just mentioned it's a gross misdemeanor, which means it's not a felony, but it's still a very serious crime. The maximum penalty is 1 year in jail and a $5,000 fine. So that's what the law is and what the penalty is. So when does it come up? Well, it comes up oftentimes at a traffic stop when someone gives a false name. You know, they're afraid they have a warrant or they have a suspended license, so they don't give the correct name or not their entire name. Another problem where it could come up is, let's say you have a friend or a child or even a parent who's in trouble, and the officers come to the door, and you don't tell the officers the truth about where they are or what you know about them. We do not have a duty to speak to the police, but we are not allowed to lie to the police, at least if it's a material statement, something they're likely to rely upon the execution of their duties. So that's another situation. It can also come up when we're being investigated by an officer and we're just not telling the truth or lying through our teeth. Now, it doesn't often get charged in that way, but I've seen a situation where on a DUI where someone says they're not drinking and later they blow on the breath test, and the next thing you know, a really mad officer might charge someone with making a false statement to the officer in that situation. So basically, most of us feel, hey, we have to do what an officer says as far as answering their questions. We don't have to. We have a right to remain silent. But if we do talk to them, it is criminal to make false or misleading material statements to officers in the execution of their duties. So that gets to number three. How do we defend these things? And maybe you've guessed it already from hearing what I've said. But one way to defend it is simply saying the statement wasn't material. It wasn't a material statement. It wasn't so serious of a misleading statement that the officer was likely to rely upon it. And I haven't thought about this ahead of time, but what might be one situation? Well, it could be, hey, I said I had a couple beers, and I later said I had 4, but the difference isn't that much. Or the officer says, hey, have you seen, your child who I'm looking for a hit and run? And you say, well, no, I haven't seen them. Later, the officer learns that you did, talk to the person half an hour ago. Well, he asked if I saw him, not if I talked to my child. So is that really false and misleading? Is it really material? How important was it, right? And so the way we want to defend things like this is say that, hey, the statement wasn't so important that it should be criminalized. Or we can also defend if you were giving a false name and then you stop for shoplifting and you're afraid, and so you give a slightly different name than your name. They don't find the name in the system. They keep pressuring you. Now you admit that what your actual name is. Well, that first statement might have been false and misleading, we can argue, hey, you corrected it later, so how bad was it really? You were scared. Human beings get scared, and therefore, prosecutor, this isn't a case you want to pursue. If you're really dead to rights on making a false and misleading statement to the officer, you claim someone beat you up or attacked you, they get arrested, and later you go back and recant, you change your story, you could get charged, and then we would want to point out, well, at least you did the right thing in the long run, about why it is that you made the false statement to begin with, and have you do some things to try to lessen the impact with the prosecutor. So there are ways to defend it. The most important thing to do if you're facing this situation is get a hold of an attorney. You're free to call our office. Again, my name's Lance Fryrear. I have the law office of Lance Fryrear. We've been defending people charged with crimes for more than 20 years. We'll listen to what you have to say, and we'll do whatever we can to help you. Again, if you find this video useful, feel free to like it. Please subscribe, and we will do everything we can to help anybody out there. We'll be there for you. Thank you.